Good day, everybody. It's Chris Bacon, the brain injured guy here again. Going on with part 3 of the oral reading of chapter probably 5 and 6 of this one. Hopefully, again, I'm trying to keep it around an hour, but so far it's been 2 chapters. We'll have to see how this one goes. Anyway, it's starting chapter 5 of the UN Guide to Parliamentarians for the rolling out the protocol and the optional protocol for persons with disabilities, human rights protocols that we've ratified and signed on to. Anyway, without further ado, hopefully again this is finding everybody well, you're all safe, and let's all step up and hopefully get some of these rights actually into action instead of just talk. Anyway, so here it goes, chapter 5. This is starting on page 51 of the actual document. Book, I should say. Document itself, don't know what page it's on right now. Anyway, chapter 5, national legislation and the convention. It is a basic principle of international law that a state party to an international treaty must ensure that its own domestic law and practice are consistent with what is required by the treaty. In some cases, the treaty may give general guidance on the measures to be taken. In others, the treaty includes specific stipulations. The Convention on the Rights of Persons with Disabilities contains both kinds of provisions. Parliament thus has a critical role in ensuring that the legislative measures required by the Convention are adopted. Many of the provisions contained in the Convention are similar in either wording or substance to the provisions of other human rights treaties to which the state is a party. It might be useful to examine how those treaties are put into effect in order to determine the steps required to implement the Convention on the Rights of Persons with Disabilities. Under the heading Incorporating the Convention into Domestic Law, the meaning of signing and ratifying. Chapter 4 explains in detail the process and meaning of signing and ratifying the Convention and Optional Protocol. In examining legislative measures to implement the Convention, one should bear in mind that, there is no time limit between signing the Convention or Optional Protocol and ratifying either instrument. Signing the Convention or Optional Protocol obliges a state to refrain from acts that would defeat the object and purpose of either instrument, and ratifying the Convention or Optional Protocol indicates at least an obligation to be bound by these instruments and to perform such obligations in good faith. One of the fundamental obligations contained in the Convention is that national law should guarantee the enjoyment of rights enumerated in the Convention. Members of Parliament should thus consider the best way of giving effect to the rights guaranteed by the Convention in domestic law. The method selected will vary according to the constitutional and legal systems of individual countries. In some countries, once it is ratified at the international level, the Convention may automatically form part of national law. In other words, the Convention would be directly enforceable by national courts and other implementing authorities. In some other countries, the legislature might have to adopt an act of ratification at the national level. This might have the effect of incorporating the Convention into domestic law. However, even when parliaments ratify the Convention, national ratification, many provisions might still require legislative action before they come into force. This depends in part on how specific the Convention's obligations are. The more specific the obligation, the less likely that implementing legislation will be needed. In other cases, including many common law countries, only those provisions of the treaty that are directly incorporated into national law will give rise to enforceable rights and duties. It's the end of that section under that heading. Back here we have a couple boxes. So I'll go back to the first one. Oh, there's actually a quote at the top of page 52 of the actual UN document. Sorry, not the PDF document. Okay, so Quote is, Uganda was one of the 82 signatories to the convention on 30th of March, and the process towards ratification is ongoing. When the convention is implemented, it will mark a significant paradigm shift to a human rights model of disability embodying principles of dignity, non-discrimination, full participation, respect, equality, and accessibility, and advance the rights and inclusion of all people with disabilities. Quoted by James Mwanda, I hope I pronounced that correctly, James, capital Mwandha, former MP for Uganda. Then there's a box at the bottom of page 52. Actions to ensure that new and revised laws comply with the convention. Governments might benefit from having a newly established or already existing body such as an Equality Commission, a National Human Rights Institution, or a Disability Commission conduct a comprehensive review of legislation. This process should include, involving experts from government institutions and ministries, civil society, and persons with disabilities in their respective organizations. Establishing and monitoring time frames for the completion of the review, and establishing a parliamentary committee to oversee the process and systemically scrutinize any legislative proposal to ensure consistency with the Constitution. End of box. On the bottom of page 53, they have another box. Constitutional guarantees of equality for persons with disability. Section 15 of the 1982 Canadian Charter of Fundamental Rights and Freedoms provides, quote, every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability, end quote. Article 3 of the Constitution of the People's Republic of China states that, quote, disabled people enjoy the same rights as other citizens in respect to political, cultural, and social aspects as well as family life, and that, quote, it is forbidden to discriminate against, insult, or harass disabled persons, end quote. Article 3 of the Basic Law of the Federal Republic of Germany states that all persons shall be equal before the law and that no person shall be disfavored because of disability. Section 38 of the Fiji Constitution, Amendment Act 1997 provides that, quote, a person must not be unfairly discriminated against directly or indirectly on the ground of his or her actual or supposed characteristics or circumstances, including ... disability, end quote. The 1995 Constitution of Uganda was drawn up with the participation of many different groups in the community, including persons with disabilities. That participation is reflected in a number of constitutional provisions guaranteeing and promoting equality for persons with disabilities. Article 21 provides that a person, quote, shall not be discriminated against on the ground of race, their sex, race, color, ethnic origin, tribe, birth, creed or religion, or social or economic standing, political opinion, or disability. See, I want to go live there. Anyway, Article 32(1) provides that the state shall take affirmative action. The state, quote, shall take affirmative action in favor of groups marginalized on the basis of gender, age, disability, or any other reason created by history, tradition, or custom for the purpose of redressing imbalances which exist against them, end quote. Article 9 of the Constitution of South Africa states that, quote, to promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination may be taken, end quote. That's pretty vague, eh? Okay, so here we are. Incorporation through constitutional, legislative, and regulatory measures. Except in the rare case that the laws in a country already conform fully to the requirements of the Convention, a state party will normally have to amend existing laws or introduce new laws in order to put the Convention into practice. Ideally, there should be a comprehensive and unequivocal legal statement of the rights of persons with disabilities and detailed legislation to make those guarantees real in practice. It is critically important that the recognition and protection of the rights of persons with disabilities be enshrined in the supreme law of the country, that is, in the national constitution or in basic laws. This will ensure the highest possible legal protection and recognition. Doing so might involve introducing disability as one of the grounds on which discrimination is prohibited, or explicitly protecting the rights of persons with disabilities in the national constitution, whether as part of a general guarantee of equality or in the form of specific provisions relating to the rights of persons with disabilities. Further, Parliament may incorporate the entire Convention into domestic law. For this case, it might be useful to include the relevant law, a clear indication that the provisions of the Convention are self-executing, that is, that they are intended to be directly enforceable before domestic courts and tribunals. However, even where the Convention is incorporated into domestic law in its entirety, this will not normally be sufficient to give full effect to its provisions. Implementing legislation will usually still be required, including detailed legislation in specific areas such as a law prohibiting discrimination in employment. In addition, it will not always be possible or appropriate for the legislature to set out in detail the rules and standards required to ensure equal enjoyment of specific rights by persons with disabilities. The state might have to adopt policy and regulatory initiatives in addition to legislation to comply with the many provisions requiring appropriate measures to be taken in areas such as physical accessibility to buildings and transport systems or information and communications technologies. Article 4 of the Convention. While parliaments might not be enacting these detailed regulations, it might be appropriate to adopt legislation that allows for standards to be set in these areas and to request that those standards be presented to the legislature for information and or approval. And at the bottom of page 55, there's another box. It's called Various Approaches to Legislation on Discrimination. It will bring us to the bottom of page 55 of the book, or of the actual article, whatever it is. At least 40 countries have adopted legislation addressing the rights of persons with disabilities. Some of this legislation prohibits discrimination as its primary goal. Other laws address the positive duty of the state and the community to ensure the welfare of persons with disabilities and their access to social support. Many countries have both types of legislation. The Americans with Disabilities Act, ADA, prohibits discrimination against people with disabilities in employment, public services, and transport, and places of public accommodation. In the employment context, the ADA essentially prohibits discrimination against qualified individuals with a disability who can perform the functions of the position held or desired with or without reasonable accommodation, which does not impose an undue hardship on the employer. Footnote 1. In India, the Persons with Disabilities Equal Opportunities Protection of Rights and Full Participation Act of 1995 adopts a more wide-ranging approach, It uses both non-discrimination language in a number of areas and also supports positive discrimination in favor of persons with disabilities through a quota system, reserving a certain number of spaces for persons with disabilities in the training and employment programs of public and private sector entities. It also provides incentives to establishments that promote the employment of disabled persons and preferential treatment through tax concessions, subsidies, and grants. Footnote 2. In 1996, Costa Rica adopted law number 7600 on equality for persons with disabilities. This law imposes clear obligations on the state to advance the rights of persons with disabilities and guarantees equality in areas such as education, health, and work. It's the end of page 55. So footnote 1, it says, is taken from DESA compilation, http://www.un.org/ESA/SOCDEV, SOCDEV, /enable/discom102.htm, and discom is DISCOM102.htm. Footnote 2 is taken from DESA compilation, http://www.un.org/ESA/SOCDEV, SOCDEV, /enable/discom102.htm. So it's exactly the same thing. when I go SOCDEV, that's all one word. I'm just going back and spelling it for you. So it's not like SOCDEV, then SOCDEV. Okay, anyway, end of page 55. New heading, Types of Equality and Non-Discrimination Legislation. The obligation to prohibit all discrimination on the basis of disability and to guarantee equal and effective protection to persons with disabilities, Article 5 of the Convention, requires both that the prohibition be included in national laws and preferably also in national constitutions, and that detailed legislative provisions covering discrimination in all fields of public and private life be adopted. The exact form that these provisions should take will depend on existing laws and the particular legal system of a state party. Some countries have comprehensive general anti-discrimination laws covering multiple grounds of prohibited discrimination. Others have individual laws dealing with different forms of discrimination, such as those based on sex, age, or marital status, or covering discrimination in specific areas such as in employment. One option is to enact a disability discrimination law that prohibits discrimination on the ground of disability in general, but that also provides detailed regulations of specified areas of public and private life. Another option might be to enact a disability equality law similar to the gender equality laws adopted by some states. Laws of this kind do not limit themselves to prohibiting discrimination, but address a wide range of issues relating to persons with disabilities. For example, in India, the Persons with Disabilities, Equal Opportunities, Protection of Rights, and Full Participation Act 1995 sets out a broad policy framework for addressing disability issues, establishes a number of bodies at the national and state level to do this, addresses prevention and early detection of disability, equality in employment and education, including affirmative action, social security, accessible transport and buildings, the recognition of institutions for persons with disabilities, research into disability issues, and other matters. Even a wide-ranging disability equality law will probably not address some issues relating to equality for persons with disabilities. Given the need for greater specificity on the issues of social security and social support, workers' compensation, transport standards, building standards, and others, it might be more appropriate to address these topics in other laws. Where legislation prohibiting other forms of discrimination already exists, it might be appropriate to amend the existing legislation to incorporate disability as a ground of prohibited discrimination. At a minimum, it is important to ensure that the Convention's understanding of disability and the definition of discrimination on the basis of disability are fully reflected in a general anti-discrimination law. Where existing legislation applies only to some of the areas covered by the Convention, then new legislation will be required to ensure that protection against discrimination on the ground of disability applies to all areas. It might also be appropriate to assign responsibility for monitoring and enforcing the law under the new legislation to existing institutions, provided that persons with disabilities are or become involved as members of those institutions, and that the institutions have sufficient expertise in disability issues. It's the end of page 57, but there's some we got to go back and review here because it was blocking too. Stop. Right, no, okay, so we got one box here. That's at the bottom of page 57. It's entitled, What Parliament Can Do to Ensure that the Convention is Incorporated into National Law. Recognize the civil, cultural, economic, political, and social rights of women, men, and children with disabilities in the supreme law of your country, Constitution or Basic Law, : Revise existing provisions in the Constitution or Basic Law and the protection granted to persons with disabilities. Include a general guarantee of equality. Prohibit the use of disability as a ground of discrimination. Include specific provisions on the rights of persons with disabilities. Revise language used to refer to persons with disabilities. Next point, adopt a national law incorporating the content of the Convention or even its entire text, specifying that the law is enforceable before the courts. Next point, adopt additional implementing legislation. Depending on existing legislation, your country might adopt or amend, : a comprehensive general discrimination law, including the prohibition of using disability as a ground of discrimination in public and private life. Non-discrimination laws in different sectors such as work, education, and access to justice, including disability as a prohibited ground of discrimination and or disability equality law, prohibiting discrimination based on disability and establishing a broad framework to address disability. Next point, ensure that there is a mechanism for consulting with persons with disabilities and or their representative organizations at the lawmaking level. And last point, revise language used to refer to persons with disabilities in all existing and new legislation. That's the end of page 57. Under the content of legislative measures, critical elements. There are a number of critical elements that are needed in implementing legislation, whether it takes the form of one or more separate laws. The legislation should, refer explicitly to the Convention and to the Convention's acknowledgement that the concept of a disability is still evolving, and to the notions of, quote, discrimination on the ground of disability, end quote, reasonable accommodation, end quote, and other important terms defined in the Convention. Point 2, prohibit discrimination on the ground of disability in all areas covered by the Convention. Point 3, identify duty bearers, including different levels of government and non-state actors. Point 4, confer rights on individuals and groups to, raise allegations of discrimination on the ground of disability, have those claims investigated, and have access to appropriate remedies. Next point, provide for independent agencies to, hear allegations of systemic discrimination and individual cases, investigate and report on those allegations, and seek systemic remedies and change through appropriate legal and other channels. Under the heading Linking Implementing Legislation to the Convention. Implementing legislation should include the terms of the Convention or a specific reference to them in order to indicate clearly that the laws should be interpreted in accordance with the letter and spirit of the Convention. The Convention is based on an understanding that disability results from the interaction between a person and his or her environment, and that disability is not something that resides in the individual as a result of some impairment. This understanding has important implications for legislation to implement the Convention, particularly in identifying the obstacles that hinder the full realization of the rights of persons with disabilities and in determining appropriate remedies. Parliamentarians might wish to consult with experts on disability issues, including persons with disabilities and the representative organizations, to update their understanding of the nature and forms of disability and the ways in which social barriers to participation can be removed. Under types of disability to be addressed in legislation, the Convention provides a non-exhaustive list of disabilities to be addressed by legislation. In other words, it sets a minimum. The Convention describes persons with disabilities as including those who have long-term physical, mental, intellectual, or sensory impairments which, in interaction with various barriers, may hinder their full and effective participation in society on an equal basis with others. That was a quote, starting with those, ending with others. This definition does not exhaust the categories of disabilities that fall under the protection of the Convention. Other types of disabilities, such as short-term disabilities, could be covered by the Convention and thus could be covered by the laws of individual states parties, especially given the social context of disability. Since Article 4, subsection 4, underlines the fact that the Convention is not intended to undermine or replace higher standards of protection of the rights of persons with disabilities under national law, it is open to a state to adopt a wider definition. A state is not required to limit its own definition to the categories mentioned under Article 2 of the Convention. That's the end of page 59 in that point. There's another box here. So I'll go back and make sure we got it all covered. Yep, okay. So the other box is at the bottom of page 59. So shifting the burden of proof in discrimination cases. Under European law, it has been found appropriate to adopt special provisions relating to the burden of proof in discrimination cases, including disability discrimination cases. For example, Article 10 of Council Directive 2000/78/EC of 27 November 2000, establishing a general framework for equal treatment in employment and occupation, provides, under burden of proof. 1. Member states shall take such measures as are necessary in accordance with their national judicial systems to ensure that when persons who consider themselves wronged because the principle of equal treatment has not been applied to them establish before a court or other competent authority facts from which it may be presumed that there has been direct or indirect discrimination, it shall be for the respondent to prove that there has been no breach of the principle of equal treatment. 1. Paragraph 1 shall not prevent member states from introducing rules of evidence which are more favorable to plaintiffs. That's the end of that box. And the end of page 59. Reasonable accommodation as a cornerstone of legislation. The Convention stipulates that a failure to afford a person, quote, reasonable accommodation, end quote, amounts to discrimination on the basis of disability. Consequently, any legislative definition of discrimination should include the denial of reasonable accommodation as an act of discrimination. Specific reference should be made to the definition of reasonable accommodation that appears in Article 2 of the Convention. Reasonable accommodation is also known as the duty to accommodate. Sorry, not the duty, it's also known as duty to accommodate. Reasonable adjustment, adaptation, or measures, or effective or suitable modifications. To afford a person reasonable accommodation means, for example, making adaptations to the organization of a work environment, an educational establishment, a healthcare facility, or transport service in order to remove the barriers that prevent a person with disability from participating in activity or receiving services on an equal basis with others. In case of employment, this might involve physical changes to premises, acquiring or modifying equipment, providing a reader or interpreter or appropriate training or supervision, adapting testing or assessment procedures, altering standard working hours, or allocating some of the duties of a position to another person. In some countries, laws may also require disability-aware procurement strategies under which public agencies may be required to give preference to equipment that is fully accessible or based on the principle of inclusive design, or to service providers who employ specified percentages of persons with disabilities in their labor force. While accommodation of the particular needs of persons with disabilities is required under the Convention, the requirement is one of reasonable accommodation. If the accommodation required would impose a disproportionate or undue burden on the person or entity expected to provide it, then a failure to do so would not constitute discrimination. In a number of countries, legislation sets out the factors that should be taken into account when assessing whether the accommodation requested amounts to a disproportionate burden. These include the practicability of the changes required, the cost involved, the nature, size, and resources of the entity involved, the availability of other financial support, occupational health and safety implications, and the impact on the operations of the entity. End of page 63. Right, and that's the end of that point. So there's a bunch of boxes back here. I've got to go back a little bit, which cover those bases. Oh, there's a few back here. Anyway, come on. Okay, so let's see now. I think that's where we need to be. Right, okay. So at the bottom of page 60, there's a box that starts, and it's entitled How Reasonable Accommodation is Addressed in Different Countries. Americans with Disabilities Act of 1990, 42 U.S.C., and then I don't know what that symbol is, subsection 12112, I guess. A, general rule. No covered entity shall discriminate against a qualified individual with a disability because of the disability of such individual in regard to job application procedures, the hiring, advancement, or discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment. B, construction. As used in subsection A of this section, the term discriminate includes 5A. not making reasonable accommodations to the known physical or mental limitations of an otherwise qualified individual with a disability who is an applicant or employee unless such covered entity can demonstrate that the accommodation would impose an undue hardship on the operation of the business of such covered entity, or B, denying employment opportunities to a job applicant or employee who is an otherwise qualified individual with a disability if such denial is based on the need of such covered entity to make reasonable accommodation to the physical or mental impairments of the employee or applicant. Spain's 2003 Law on Equality of Opportunities, Non-Discrimination, Universal Accessibility of Persons with Disabilities provides for reasonable adjustment, ajuste raisonnable. Ajuste raisonnable is defined as, quote, the measures of accommodating the physical, social, and attitudinal environment to the specific needs of persons with disabilities which in effective and practical form and without supposing a disproportionate burden facilitate the accessibility or participation of a person with a disability in equal conditions as the rest of the citizenry, paragraph 7c. United Kingdom's Disabilities Discrimination Act of 1995 legislates the duty of employers to make adjustments, section 6.1. This duty applies to where any arrangement or any physical feature of premises of employer places the disabled person concerned at a substantial disadvantage in comparison with persons who are not disabled, end quote. In such a case, quote, it is the duty of the employer to take such steps as it is reasonable in all the circumstances of the case for him to have to take in order to prevent the arrangements or feature having that effect, end quote. Subsection 6.3 specifies examples of steps an employer may have to take to comply with this duty, and bullet points, making adjustments to the premises, allocating some of the disabled person's duties to another person, transferring him or her to fill an existing vacancy, altering his or her work hours, assigning him or her to a different place of work, allowing him or her to be absent during work hours for rehabilitation, assessment, or treatment, giving him or her, or arranging for him or her to be given training, acquiring or modifying equipment, modifying instructions or reference manuals, modifying procedures for testing or assessment, providing a reader or interpreter, providing supervision. According to the Magna Carta for Disabled Persons of the Philippines, in the employment context, reasonable accommodation includes, quote, 1, improvement of existing facilities used by employees in order to render these readily accessible to and usable by disabled persons, and 2, modification of work schedules, reassignment to a vacant position, acquisition or modification of equipment or devices, appropriate adjustments or modifications of examinations, training materials or company policies, rules, and regulations, the provision of auxiliary aids and services, and other similar accommodations for disabled persons, section 4H. In relation to the provision of public services and public accommodations, the Magna Carta for Disabled Persons provides that discrimination includes, quote, a failure to make reasonable modifications in policies, practices, or procedures when such modifications are necessary to afford such goods, services, facilities, privileges, advantages, or accommodations to individuals with disabilities unless the entity can demonstrate that making such modifications would fundamentally alter the nature of the goods, facilities, services, privileges, advantages, or accommodations. Section 36, subsection 2. That's the end of that box. And then there at the top of page 63, there's another box. Disability-aware procurement strategy in the United States of America. In some countries, legislation requires the government to give preference in its public procurements to equipment and technology that meets accessibility, universal, and inclusive design standards. For example, Section 508 of the U.S. Rehabilitation Act of 1973, 29 U.S.C. subsection 794D provides, it's on electronic and information technology. A, requirements for federal departments and agencies. 1, accessibility. A, development, procurement, maintenance, or use of electronic and information technology. When developing, procuring, maintaining, or using electronic and information technology, each federal department or agency, including the United States Postal Service, shall ensure, unless an undue burden would be imposed on the department or agency, that the electronic and information technology allows, regardless of the type of medium of the technology. 1. Individuals with disabilities who are federal employees to have access to and use of the information and data that is comparable to the access to and use of the information and data by federal employees who are not individuals with disabilities. And 2. Individuals with disabilities who are members of the public seeking information or services from a federal department or agency to have access to and use of information and data that is comparable to the access to and use of the information and data by such members of the public who are not individuals with disabilities. Boy, that's a tongue twister. See, tongue twister. I almost said the wrong way. Alternative B, alternative means efforts. When development, procurement, maintenance, or use of electronic and information technology that meets the standards published by the Access Board under paragraph 2 would impose an undue burden, the federal department or agency shall provide individuals with disabilities covered by paragraph 1 with the information and data involved by an alternative means of access that allows the individual to use the information and data. End of box. Then at the top, page 64, there's another box called disproportionate or undue burden. 2003 Spanish law on equality of opportunities, non-discrimination, and universal accessibility of persons with disabilities, providing for reasonable adjustment, ajuste raisonnable, uses the term, quote, disproportionate burden, or carga desproporcionada in its legislation. Article 7 provides that, quote, to determine whether a burden is proportional or not, one must take into consideration the cost of the measure, the discriminatory effects failure to adopt the measure would imply for the persons with disabilities, the structure and characteristics of the person, entity, organization that must implement it, and the possibility of obtaining official financing or other assistance, end quote. Under United Kingdom's Disability Discrimination Act, an employer discriminates against a disabled person if two conditions are met. Quote, A, he fails to comply with a Section 6 duty to make reasonable adjustments imposed on him in relation to the disabled person, and B, he cannot show that his failure to comply with that duty is justified. Section 6.4 of the Act lists key factors that must be considered in determining whether it is reasonable for an employer to take a particular step in order to comply with the duty to make reasonable adjustments. A, the extent to which taking the step would prevent the effect in question. B, the extent to which it is practicable for the employer to take the step. C, the financial and other costs which would be incurred by the employer in taking the step, and the extent to which taking it would disrupt any of his activities. D, the extent of the employer's financial and other resources, and E, the availability to the employer of financial or other assistance with respect to taking the step. Under Australian Disability Discrimination Act of 1992, employers, educational authorities, and others are required to make reasonable adjustment as long as this would not impose an unjustifiable hardship or be unreasonable. Section 11 provides that in determining what constitutes unjustifiable hardship, all relevant circumstances of the particular case are to be taken into account, including the nature of the benefit or detriment likely to accrue or be suffered by any persons concerned, the effect of the disability of a person concerned, financial circumstances, and the estimated amount of expenditure required to be made by the person claiming unjustifiable hardship, and in the case of the provision of services or in making available of facilities, an action plan given to the Commission under Section 64. Sorry. I need a drink here. Sorry. With regard to the cost to the employer, the Australian Human Rights and Equal Opportunity Commission specifies that consideration should be given to, quote, the net costs or benefits which are identifiable or reasonably likely to result overall for the employer, not simply the direct or upfront or gross costs, end quote. This may require taking into account direct costs, any offsetting tax, subsidy, or other financial benefits available in relation to the adjustment or in relation to the employment of the person concerned. Indirect costs and or benefits, including in relation to productivity of the position concerned, other employees in the enterprise. Any increase or decrease in sales, revenue, or effectiveness of the customer service. How far an adjustment represents any additional cost above the cost of equipment or facilities that are or would be provided to an employee similarly situated who does not have a disability. How far an adjustment is required in any case by other applicable laws, standards, or agreements, and relevant skills, abilities, training, and experience of the person seeking the adjustment. In addition to considering the financial costs and benefits of making the adjustment and the benefit of providing equal opportunity, treatment, or participation to the person with a disability directly concerned, one might also consider any benefit or detriment of the adjustment concerned for access or opportunity for other employees or potential employees, customers, or clients, or other persons who would possibly be affected. The benefit or detriment of the adjustment concerned to the effective organization of work in the enterprise or workplace concerned regarding the number of employees, the spatial organization of work, the nature of the work to be performed, relevant customer requirements, workforce planning needs, any downtime or interruption to production involved in making the adjustment, and any other factors affecting the efficiency, productivity, success, and, where relevant, competitiveness of the enterprise. Whether the adjustment would impose unreasonable requirements on other employees. The nature and likelihood of any benefit or detriment to the health or safety of any person in making the adjustment. The nature and likelihood of any environmental benefit or detriment as a result of making the adjustment, and whether the adjustment concerned would assist or interfere with compliance with applicable provisions of other relevant laws, standards, or agreements, and the nature and likelihood of any other benefit or detriment as a result of making the adjustment. End of the box. And it's also, we are now at the new heading. And I'll take a short break. Special measures. Legislation should not be limited to prohibiting discrimination, but might also require the state and private actors to take positive measures. Article 5, subsection 4 of the Convention recognizes that in order to ensure equality with others, it may sometimes be necessary to provide special support for particular individuals or for persons with particular types of disabilities. This may take two forms: ongoing or permanent measures. These are special measures that will be ongoing or possibly permanent. For example, in order to ensure that persons with disabilities are mobile as others, governments might provide a travel subsidy for disabled persons to enable them to use taxis. Temporary special measures. These are measures that are adopted to redress the past disadvantage of persons with disabilities, but which may be intended to operate only for a period of time. For example, a government might set targets or quotas for the employment of persons with disabilities with the goal of removing the quotas once the targets have been achieved. Both ongoing and temporary special measures are permissible under the Convention and do not constitute discrimination as defined by the Convention. Indeed, both types of special measures might be necessary in order to achieve equality, and therefore a state party will be obliged to adopt a range of special measures across different areas of social life. Sometimes when special measures of this kind are adopted to redress the historical and continuing disadvantage suffered by members of a group, the measures are challenged by persons who do not belong to that group on the ground that they are discriminatory. Parliaments must ensure that any constitutional or legislative guarantee of equality makes it clear that special measures mentioned in the Convention are lawful under national law and are not subject to challenge under other equality guarantees by persons who do not have disabilities, but who claim that their exclusion is a violation of their equal rights. Parliaments also have a special role in raising awareness in the wider community of the need for special measures and their benefit to society as a whole. Laws might also require government departments and even private corporations to report annually on the steps they have taken to promote the rights of persons with disabilities. Reporting requirements might cover a range of issues, including the steps taken to ensure that the rights of persons with disabilities are being guaranteed in practice, success in raising the percentage of employees who are persons with disabilities, or success in improving services to customers with disabilities who might have special needs. End of that section. There's another box here at the bottom of page 67 of the actual document. State parties' obligations to regulate the private sector. state parties undertake to take all appropriate measures to eliminate discrimination on the basis of disability by any person, organization, or private enterprise. Article 4, subsection 1E. States parties undertake to encourage all organs of the media to portray persons with disabilities in a manner consistent with the purpose of the present convention. Article 8(2), subsection 3C. States parties shall also take appropriate measures to ensure that private entities that offer facilities and services which are open or provided to the public take into account all aspects of accessibility for persons with disabilities. Article 9(2), subsection B. States parties shall require health professionals to provide care of the same quality to persons with disabilities as to others, including on the basis of free and informed consent inter alia, raising awareness of the human rights, dignity, autonomy, and needs of persons with disabilities through training in the promulgation, promulgation, promulgation of ethical standards for public and private health care. Article 25D. States parties shall safeguard and promote the realization of the right to work, including for those who acquire a disability during the course of employment, by taking appropriate steps, including through legislation to inter alia, promote the employment of persons with disabilities in the private sector through appropriate policies and measures, which may include affirmative action programs, incentives, and other measures. Article 27(1), subsection H. It's the end of page 67. Next section, discrimination by state authorities, private persons, and corporations. It is a central component of the Convention that persons with disabilities should be protected against discrimination by both public and private actors. Therefore, an anti-discrimination law or other legislative measures that prohibit discrimination and mandate equal treatment should apply to private individuals, bodies, or corporations, as well as to public officials and bodies. The Convention also obliges states to regulate the private sector. Specific areas for legislative reform. The Convention specifies a number of areas that require legislative guarantees or protection. Article 12(1) of the Convention reaffirms the right of persons with disabilities to recognition as persons before the law, and Article 12(2) recognizes that persons with disabilities have the right to use their legal capacities as others do. Article 12(3) underlines the need for measures to support the exercise of that capacity, while Article 12(4) calls for the establishment of safeguards to ensure there is no abuse of this right. Since denying legal capacity to persons with disability has led to egregious violations of their rights, any law reform process should address this issue as a matter of priority. Parliament should examine existing law to determine if there are any formal limitations on the capacity of persons with disabilities and if the provisions of the law and practice conform to the Convention. Parliament should also consider whether, despite formal guarantees of respecting the legal capacity of persons with disabilities, legal capacity is respected in practice. The Convention specifically requires states to take appropriate measures to ensure that persons with disabilities who need assistance in exercising that capacity receive it. Case in point. Convention also contains a number of guarantees concerning areas where the rights of persons with disabilities have been and continue to be denied. These include the right to liberty and security of the person, Article 14, and the rights to freedom from torture and freedom from exploitation, violence and abuse within and outside the home. A state should carefully review its laws and their operation, particularly in areas such as the deprivation of liberty of persons with disabilities, especially those with intellectual disabilities. For example, states should note the Convention's emphasis on the independent living within the community instead of forced institutionalization. States should also review these guarantees in relation to compulsory or forced medical interventions and should ensure that there are laws and procedures to monitor the operation of this legislation, investigate cases of abuse, and impose punitive measures as necessary. Article 16, subsection 4. There's a box just before that. It covers bottom of page 69 and top of page 70. It's entitled States That Recognize National Sign Languages. The Constitution of Uganda. Oh, actually, let's just double check. There's nothing else about that. Right. Okay. So, states that recognize national sign languages. The Constitution of Uganda specifically recognizes sign language and the duty of the state to foster its development. Article 24 of the Constitution provides, quote, the state shall promote the development of a sign language for the deaf, end quote. Section 17 of the Constitution of Finland, 1995, Section 17, right to one's language and culture provides that, quote, the rights of persons using sign language and of persons in need of interpretation or translation aid owing to disability shall be guaranteed by an act, end quote. Article 101 of the 1999 Constitution of the Bolivarian Republic of Venezuela provides, quote, the state guarantees the issuance, receiving, and circulation of cultural information. The television media shall include subtitles and translation to Venezuelan Sign Language for persons with hearing problems. The terms and modalities of these obligations shall be established by law, end quote. Thai Sign Language was acknowledged as, quote, the national language of deaf people in Thailand in August 1999 in a resolution signed by the Minister of Education on behalf of the Royal Thai government. In 2006, the New Zealand Sign Language Act entered in, in 2006, the New Zealand Sign Language Act entered into force. That statute provides for official recognition of the New Zealand Sign Language, NZSL, which is the first or preferred language of deaf New Zealanders. The Act recognizes deaf people's language as a unique New Zealand language and thus gives NZSL equal access to that of spoken languages. The Act provides for any person involved in legal proceedings to use NZSL in those proceedings. The Act also provides that the deaf community should be consulted on members that affect their language, including, for example, the promotion of the use of NZSL. That NZSL should be used in promoting government services and providing information to the public, and that government services and information should be made accessible to the deaf community through appropriate means, including the use of NZSL. The Act also provides that the government department should, as far as reasonably practicable, be guided by certain principles about their interaction with the deaf community, Clause 9. Nothing in this clause should be read as conferring advantages on the deaf community that are not enjoyed by others, Clause 9.2. Then the next box is entitled Remedies. Under the Disability Discrimination Ordinance of 1995, when a claim of disability discrimination comes before a district court in Hong Kong Special Administrative Region of China, the court has wide-ranging remedial powers, which include the power under Section 72 to A. Make a declaration that the respondent has engaged in conduct or committed an act that is unlawful under this ordinance and order that the respondent shall not repeat or continue such unlawful conduct or act. B. Order that the respondent shall perform any reasonable act or course of conduct to redress any loss or damage suffered by the claimant. C. Order that the respondent shall employ or re-employ the claimant. D. Order that the respondent shall promote the claimant. E. Order that the respondent shall pay to the claimant damages by way of compensation for any loss or damage suffered by reason of the respondent's conduct or act. F. Order that the respondent shall pay to the claimant punitive or exemplary damages. Or G. Make an order declaring void in whole or in part, either ab initio or from such date as may be specified in the order, any contract or agreement made in contravention of this ordinance. End of box. Next subsection, intellectual property laws and ensuring access to books, films, and other media. States parties should examine their intellectual property laws to ensure that they do not hinder persons with disabilities from accessing cultural materials. A number of countries have adopted such legislation in adherence to other international obligations, such as those under treaties with the World Intellectual Property Organization and the World Trade Organization. Under legislation recognizing national sign languages, the Convention obliges states parties to recognize and promote the use of sign language. This would likely require some implementing legislation. Under complaints procedures under national law, legislation should ensure that a person who has been subjected to unlawful discrimination is able to obtain an effective remedy. Remedies might include compensation or damages, an order of reinstatement, an order to stop discriminatory acts and prevent them in the future, a requirement to afford reasonable accommodation to the individual's rights, an apology, an order to take wide-ranging remedial measures, including positive action or other measures. Under the discrimination law of a number of countries, once a complainant has established facts from which discrimination may be presumed to exist, the burden of proof shifts to the defendant to demonstrate that the treatment was not based on a prohibited ground of discrimination, or if it was, that it fell within permitted exception to the prohibition of discrimination. Given the difficulties that complainants in discrimination cases often face in adducing direct evidence of discrimination, this is an important dimension of procedural law that should be addressed. See box on various approaches to discrimination legislation on previous page. That's what I just read. Procedural measures to promote implementation. The role that parliamentarians might play in the lead up to ratification has been discussed earlier in this handbook. Once a state has ratified or acceded to the convention, significant obligations arise, and legislatures can play an important role in ensuring that they are met. As first steps to take after the convention is signed and ratified, Parliament should undertake a comprehensive review. Article 4(1)b of the convention obliges states parties to, quote, to take all appropriate measures, including legislation, to modify or abolish existing laws, regulations, customs, and practices that constitute discrimination against persons with disabilities, end quote. Accordingly, one of the most important steps that a state should take as soon as possible after it has become a party to the convention, and preferably after it has signed the convention, is to undertake a comprehensive review of existing law to determine to what extent it is consistent with the treaty. The state should also identify any new legislative and policy measures to be undertaken in order to give effect to the convention. A detailed timetable for this legislative review and reform should also be adopted. A comprehensive review of this kind can be particularly useful for the state when it prepares its initial report under the convention, due within 2 years of ratification. The initial report will set a baseline for the realization of the rights of persons with disabilities, indicate the areas where reform is a priority, and help to develop a program to improve the situation in a deliberate, planned, and monitored manner. There are a number of ways in which such a review might be conducted. A special independent statutory body might be established to conduct the review and report to the government, or an existing body such as an Equality Commission, National Human Rights Commission, or Disability Commission might be assigned the task. Parliament itself might establish a committee to oversee the process or assign that task to one of its existing bodies. The framework of the convention should be the standard against which the level of enjoyment of human rights by persons with disabilities is measured. Persons with disabilities should participate extensively in the process, both as members of the review body and as contributors. The review should not be a one-time event. The body should either be given continuing responsibility for oversight or should ensure that there is an independent review of the implementation of its recommendations after a reasonable period, for example 3 to 5 years. It's the end of that heading. Now, going back a bit, because there's a box here and that too. And I think I'll take a break for a bit. Okay, I think we're here. On the page of 72 of the document, which is page 84 of 163 of the actual PDF file, because it's two different things. The PDF file is ipuhb.pdf, which is page 84 of 163. If you're talking the actual document itself, physical document, it would be, like I said, on the bottom of, or top of page 72. Critical issues that should be addressed in legislative measures. Any legislation should be based on the understanding that disability is a result of the interaction of the person with the environment, and that persons with disabilities are entitled to civil, cultural, economic, political, and social rights on an equal basis with others. Discrimination on the ground of disabilities, including the denial of reasonable accommodation as a form of discrimination by the private and public sectors, is prohibited. Persons with disabilities should be included and participate in all aspects of society, including political public life, ensuring consultation with persons with disabilities in the implementation of the convention, and policies or laws affecting them, revision of election laws, etc. Cultural life, recreation, leisure and sport, and education. The physical environment, transport technologies, information and communications, and public facilities and services should be accessible. Specific measures of a temporary or permanent nature should be incorporated to accelerate or achieve de facto equality. The rights of individuals and groups to civil, criminal, and administrative action against discrimination based on disability and appropriate remedies should be ensured. Any definitions of types of disability should be in accordance with Article 2 of the Convention. The rights of persons with disabilities as persons before the law and recognition of their legal capacity, including supportive measures and necessary safeguards, should be ensured. Persons with disabilities should have access to justice, entailing procedural accommodations at all stages of legal proceedings. A national mechanism to monitor the implementation of the Convention should be established. It's the end of that box, and the end of page 84, 163, or page 72 of the actual document. Okay, so where are we? Okay, now on the top page 73, there's another quote. It's a sidebar quote, so I will read that. Quote, South Africa has made a lot of progress in the area of disability self-representation policy reform. This convention, however, will cement and ensure that despite the change in political dimension, if and when it happens, the country will be able to continue to protect and have a responsibility to disabled people and their families, as well as ensure that they are treated as first-class citizens like all other non-disabled peers. That's a quote by Henrietta Bogopan Zulu. I hope I pronounced that correctly. It's spelled Hendrietta, capital BOGOPANE hyphen, capital ZULUMP for South Africa. Under the heading, ensure that all laws are consistent with the Convention. Ensuring that new laws and regulations are consistent with and advance the goals of the Convention is as important as reviewing existing laws. The Convention obliges states to take the rights of persons with disabilities into account in all policies and programs, Article 4(1)(c). Government officials should thus ensure that their proposals comply with the Convention when they are developing policies and legislation. The legislature has a critical role to play in scrutinizing new legislation. Parliament should ensure that there is a stage of the legislative process in which legislation can be examined for its compliance with the Convention. This might involve establishing a committee of its members to review legislative proposals, or handling that responsibility to an existing committee or committees that scrutinize legislation for adherence to human rights principles. Once again, it is essential to include persons with disabilities and disability organizations in this process. Parliaments may need to make special efforts to ensure that persons with disabilities are aware of the processes and of draft legislation, and to facilitate the submission of their views to the legislature. Some parliaments require the executive branch of government to provide a statement of affirming that the legislation is compatible with relevant international standards, or to provide an assessment of the impact of the legislation on a particular group when it presents draft legislation to Parliament. A disability impact statement, either freestanding or as part of a human rights impact assessment, would help to focus the government's attention on the issue. Short break. Actually, I'm going to push ahead because I just found out that I'm almost at the end of Chapter 5. So we'll just push on through. Engage person with disabilities in the legislative process. Persons with disabilities should be actively engaged in drafting legislation and in other decision-making processes that affect them, just as they were actively engaged in drafting the convention itself. They should also be encouraged to offer observations and guidance when laws are implemented. There are a variety of ways to ensure that all views are considered, including through public hearings with sufficient advance notice and publicity, by inviting written submissions to the relevant parliamentary committees, and by sharing all comments received with the wider public through parliamentary websites and other media. Footnote 3. Parliament should ensure that its laws, proceedings, and documentation are made available in accessible formats such as large print, braille, and plain language in order to ensure that persons with disabilities can fully participate in developing legislation generally and specifically in relation to disability issues. The premises of Parliament and other venues where it may hold hearings should also be accessible to persons with disabilities. Footnote 3. A more comprehensive discussion on citizen involvement in the parliamentary process can be found in Parliament and Democracy in the 21st Century, A Guide to Good Practice, Geneva Interparliamentary Union, 2006, pp. 79 to 87. So I guess that's pages and paragraph 79 to 87. Anyway, involve provincial or state level parliaments. Mirroring the language of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, Article 4.4 of the Convention states that the Convention's provisions, quote, extend to all parts of federal states without any limitations or exceptions, end quote. In some federal states, the primary responsibility and power to implement certain provisions of the Convention might rest with the provinces or constituent units. A failure to exercise that power could render the state as a whole in breach of its international obligations. There is no defense that the central government did not formally have power in that area. This provision does offer some opportunity, since provincial or state legislatures might be able to implement their own legislative and other initiatives within the area of their competence to give effect to the provisions of the Convention, adding to any measures that are undertaken by the central government. So that's the end of page 76. There's at the bottom of page 75, there's another box, which is the checklist for parliamentarians. How I can help translate the convention into national law. Ensure that the supreme law of the land, constitution or basic law, protects and recognizes the civil, cultural, economic, political, and social rights of persons with disabilities. Ensure that existing legislation is reviewed for its compliance with the convention. Ensure that all areas included in the convention are incorporated in national laws, both existing and new laws. Ensure that persons with disabilities and their organizations are consulted during the lawmaking process. Ensure that the relevant institutions and mechanisms are established at the Parliament level to ensure that any new legislation adopted is consistent with the Convention. Ensure adequate funding is allocated in the national budget for various sectors relevant to the realization of the rights of persons with disabilities. Make use of parliamentary procedures such as oral and written questions, submission of bills, and parliamentary debate. Raise awareness about the rights of persons with disabilities through debate within your political party, alliances with other parliamentarians to strengthen your lobbying capacity, partnerships with organizations of persons with disabilities, and public information campaigns. It's the end of that box and end of page 75, and if I'm not mistaken, it's also the end of chapter 5. And we're up on an hour. So, gee, that was a long chapter, I guess. Okay, so I guess the next one's coming back with chapter 6. Hope this finds everybody well. I need a break right now anyway, so gonna try and come back with some more. Hopefully it's you're finding it helpful, not too boring. Sorry about the sniffling and the coughing. Anyway, I hope this is finding everybody safe out there, and you're responsible for your own safety as well. But hey, you know, look out for the next guy too. You never know, and pay it forward. We can all probably do better. Anyway, this is Chris Bacon, the brain injured guy, signing off for now. Again, public service announcement, and all you judges and lawyers out there, and lawmakers and parliamentarians, you know, again, feel free to utilize this opportunity. It could at least, you know, I know you're very busy with a lot of other stuff, but you never know. It might be good to listen to on the way home. A little relaxing. Maybe not too much. You fall asleep behind the wheel. And definitely don't be reading it on your iPhones when you're coming home, because that's illegal too, isn't it? Oh, maybe you're privileged. Who knows? Anyway, I guess we find out when we get to court who's privileged and who's not, right? I mean, you're even putting in the documents now. Anyway, here's hoping. Brain injured guy, signing out.